9/22 of 2022. Honorable Supreme Court of India has passed an order for early hearing. Mr. Tripathi, Suresh Tripathi is the conducting counsel. He has requested to list the matter on either on 29th or 30th.
You
At
give
a
it,
two-
we'll see how
at
can
2
we
p.m.
adjust. Take it, let us see.
I want to mention, Milord,
Yes.
that CMP number 997 of the 2022. The petitioner is enjoying the IA proceeding of the
Give
stay.
the number.
I want to make a mention, my lord. CRLA vigilance appeal matter, my lord. Process already completed, my lord. Written argument citation also sought to the opponent advocate. I have to make fixed date.
Appeal, na? Including the weekly.
And another two matter, my lord. There is a compromise already held, arrived by the parties, my lord.
What
One
are the offences?
check bounce case, another is 420 IPC, my lord. Already settled, compromise filed, my lord. Also kindly be fixed a date, my lord.
Oh, compromise. Tuesday.
This divorce proceeding allowed, madam. Divorce proceeding allowed subject to payment of rupees 7 lakh real money. The opposite party filed for 98 proceeding before the trial court, madam. He agreed to settle the matter, but the conducting lawyer he can disturb another.
My lord, CRLMC number 114 of 2022, lastly listed on
Give the
28
memo. Give the
28 January.
Give the memo. Any mention?
Any mention item number 1 to 4, 5 to 18,
Lordship, item 7, pray for my action.
That's 7 and the request of counsel for the petition. Yes.
item 19 to 32,
17. My lord, item 24. Right, 17.
17.
17.
Yes.
Sir, already divorce has been made by both parties, but intentionally the wife filed for 98 case.
Now, what do you want? You want to argue the matter?
Sir,
Wait. Yes. Yes.
item 24 by
24.
24.
Yes. Okay.
33 to 40, 41 to 43.
This 43 is a matter of the lordship will please to fix at 3:30 p.m. since the lordship's court is for not functioning today.
41, huh?
43. The lordship may fix kindly, but time may not be given now because this otherwise you would have reached at 12:30.
Yes.
But because of the time it cannot be taken up, I can't ask.
You tell me when.
Sir, any time of 7, I was, if your lordship can be commencing 21st, 22nd, 22nd, 23rd.
Yes. 21st, 22nd.
Without time now.
22nd.
Sir, our timeline is.
Let it come at any time. Yes.
Grateful, sir.
22nd.
Entry order to continue.
Entry mode to continue. 27.
44 to 47.
Item number 45, my lord. Your last occasion, your lordship sent it to mediation center, and mediation date is fixed to tomorrow.
Tomorrow. Mediation tomorrow. Release it after. Keep it on 16th.
Entry model to continue.
Entry mode.
48 to 51. Item 1.
On behalf of Mr. Maharana, my lordship, kindly pray for some other day. He is
Okay,
not
yes.
well, my lordship.
Yes.
Item 2.
Item 2, may I please your lordship?
And this lordship was directed to give the status report. He was on leave for 1 month. Recently he joined. So another some time will give him. Your lordship was directed by.
State submits that the superintendent of police Hon'Ble was supposed to submit a report who was on leave for a month. Therefore, he seeks 1 more week to file the status report. Release the matter after 2 weeks.
It's a small.
2 weeks.
Yes, your lordship. Let them submit the status report and we'll be permitted to file a reply on it.
Status report which apply to the council for the petition. Yes.
Item 3.
Item 3, the matter has been compromised.
Petition, the notice will be issued in the same matter. The parties will
You
argue.
are not implemented victim.
Your lordship,
Victim also you implement.
Victim was a minor in our.
You have to simply say because she has already settled it. He's married with his
Yeah.
boy.
Yes, yes, Lordship. They're married. They're married in a Shiv temple.
Ali, please notice.
One more thing is that, Your Lordship, out of 18 suspected witnesses, Your Lordship, till December 2024, 18 witnesses have been examined. And case is now verge of completion. So for my
So at this stage, how can I help you?
The hearing stage is going on, Your Lordship. One notice may be issued. It's not.
No, notice. How can I issue notice if the trial is going on at the advanced stage of trial? How can I
The
interfere in
parties
this?
have entered on an amicable settlement, Your Lordship. The outcome.
You can do that there in the trial court.
They have already proceeded because they had already.
See, the
started
victim might have deposed against you.
No,
No, Your Lordship, the
PW7,
position.
my lord, alleged to the statement of the victim. It is PW7, Your Lordship. Kindly glance for a
Is it
moment.
to 7?
Yes, Your Lordship.
Yes.
No, sir. Page 60 or running page.
60.
Yes, sir.
Yes. Yes.
I am the witness is reading in plot 2, first year in the Sudhananda College and after passing matric, is quite competent and capable to understand it appears from the evidence and
Come to the main point.
but it doesn't support the case of the election. We have 61.
The victim has herself agreed that she was in a relationship with the petitioner with her own sweet will, Your Lordship. The parties have amicably resolved the matter outside of the
Madam,
court,
I
Your Lordship.
try to appreciate party might have been in a compromise this thing. But the fact is the witnesses have already been examined. How can I scuttle the trial at the fake end of the trial?
The trial is
You
ongoing.
have to answer that.
Because the compromise could not be brought to the learned court because that could not be quashed.
I can't ignore the evidence which has come.
Evidence are in support of the.
Because it's POCSO case.
Yes, Your Lordship, but the same I didn't personally nature.
Have you read the judgment? Rosalind judgment you have read?
Yes, yes, the judgment that I have posted.
That judgment is against you now. You read it and come. I'll just simply end. Okay, simply end. Yes.
So short date.
Simply. I'll not dismiss it. Otherwise, I would have dismissed. Since you are appearing, I'm not dismissing it. Just read it and come. Okay. Yes.
13.
May I please, Your Lords? My Lord, here the petitioner challenges the order dated 28/7/2023 passed by the Revisional Court, my Lord. The operating part is at page 19, my Lord. The Revisional Court allowed my petition for release of vehicle, but imposed the condition regarding, my Lord, furnish the cash security and bank guarantee. I am permitted to furnish.
Where is that condition?
My Lord, page 19. First para. Accordingly, the petitioner has filed for release of vehicle under section 397. Service is allowed with condition that the owner of the vehicle shall furnish cash security and bank guarantee as per the value reflected in the vehicular documents, such as insurance of the vehicle. My Lord.
The owner of the vehicle shall furnish the cash security and bank guarantee.
My Lord.
As per the value reflected in the vehicular documents. What is the value?
Value, my Lord, 2,50,000.
2,50,000.
My Lord. My Lord, property. I may be permitted
and
to.
bank guarantee.
My Lord.
Value of the tractor and trolley is not.
Where is the valuation? Where does it?
The vehicle is not annexed to the application.
Just to.
Where is the valuation? Where from I get it?
My Lord.
Where is the valuation? Where does it?
My Lord, the insurance just to avoid the defect, my Lord, not so visible. Therefore, I have not filed.
But you tell me where from I'll get that value?
My Lord.
In the order or somewhere else?
Order there is not reflected.
People don't file anything. That's the whole difficulty.
My Lord, in order also not reflected. Just to avoid the insurance certificate, my Lord, which is not.
So what do you want to? Bank guarantee will give, but not cash security.
Property security of the vehicular. My Lord.
You are the accused.
No, my Lord.
Then?
Father of the driver, my Lord.
Father of the?
Driver. Owner is the.
Driver is the accused.
Driver. Son is the accused, my Lord.
You are the owner.
My Lord.
Ownership is not doubted, just see.
My Lord.
Impugn order.
Page 16.
Page 10, my Lord. Mrutyunjay Biswal is the accused. Father name Bijay Kumar Biswal. Bijay Kumar Biswal is the present petitioner, my lord.
This order is passed in revision.
My lord.
Where is the principal order,
My lord.
main order, against which you filed the
Revision, my lord.
revision? That also you have not filed. File those documents. See, you
My-
have challenged a particular order in the revisional court. The revisional court passes some order.
My lord.
You don't file anything. Directly revisional order and you say that allow. How can it be possible? This should place on record.
My lord, in similar case, my lord, directed to furnish the property security as per the vehicular.
I don't know what is the value of the nothing is placed on record. No document is filed. Impure order is also not filed. File the document. I'll put it after 1 week. Then counsel for the petitioner takes an adjournment for a week to place on record the additional document to substantiate the case. Let him do so. Please the matter after 1 week. File all these documents, then only.
My lord, obliged.
I'll convert it to property security, but you have to place it on record. Yes. What will you?
May I please, Your Honor? My lord, petitioner wants to against cognizance passing of the affair, my lord. My lord, petitioner, present petitioner is an mediator in this above noted case, matters offense under section 420, 406, 468.
Challenging cognizance order.
Yes, my lord. Now the stage is accused statement stage, my lord. Petitioner's prayer, my lord. Your lordship's court, he has paid total amount of the 3 lakh within 6 months in installment, maybe consider, my lord. He's a mediator, my lord. He has a day by day allegation this that health condition is getting deteriorated day by day. So he was mental agony now in this stage. He was petitioner wants to repay total amount of the 3 lakh.
We repay in the trial court. That will be concluded.
Trial court
at the stage of recording of the accused statement. Why have you come here?
Total cross examination he hai.
Then you have to make appropriate application for trial court, madam. How can I quash cognizance order when the evidence and everything is recorded?
Se dei deba total amount
statement is going on and you
total amount hobe dei deba ku chahuchi. Your lordship prayer karchi 6 installment re dei deba pai bhi chahuchi.
But he has to, the other side has to be agreeing. You go and tell that in the trial court. I'll record that and dismiss it. And you go, the trial court will make an effort for settlement because of your concession.
Kindly consider this application.
How can I issue notice also? I can't issue notice because the facts are set. Can you bring him, the opposite party number 2? Can you bring him? Yeah.
Try.
You have not filed any document also. That's the problem. What is her? What is his statement before court?
Only order sheet, my lord, I submitted.
Order sheet will not. What is the statement of the informant before the court? Deposition before court.
Yes, my lord. Already deposit. This deposition copy already deposited.
Where is that deposition?
Annex 1 series, my lord.
Where is the deposition? Please. This is all these are proceedings.
May kindly be issue notice.
Madam, issue notice is not routine work. I can't issue notice unless you satisfy me. How can I issue notice in this stage? The moment I issue notice, you people will go and tell that High Court is of the matter.
My lord, all deposition here, my lord.
No. You have to satisfy me. Where is the evidence? Where is nothing is there?
All depositions here, Annex 1 series, my lord.
Not depositions, madam. It is all proceeding before the court below. There is a difference between deposition and this thing.
Kindly be taken up next week. I will submit all the document and depositions.
Seeks an adjournment to file
Issue notice.
additional document.
Maybe issue notice for opposite party.
The matter of yes.
15.
Seek an sought adjournment, your lordship, because Mr. Mishra
Adjournment.
was to do this matter.
Huh?
Mr. Mishra was to do this matter, but due to his medical emergency, he is not
Okay. On behalf of the counsel for the petitioner and adjournment is sought. As there is the medical emergency, counsel for the petitioner is attending to a medical emergency.
Pardon me. Kindly stay the proceeding, Mr.
Madam, I'm not issuing notice because you have to file the document. I can't pass any order in your case. You file the document, then we'll see what can be done. Yes.
Much obliged.
60,
The rejection of order dated 26/11/2024, my lord, wherein, my lord, the learned session judge, my lord, has confirmed the order passed by the STGM Bhawanipatna, my lord. What happened in this case, my lord? My lord, cyber fraud was made against me, my lord, and some amount was defeased by the IO, my lord. In this connection, my
You
lord.
are the victim.
Yes, ma'am.
You want release of that money.
Yes.
Against the confirming order, my learned senior has not filed the trial court order.
I issue notice, just check it up.
Yes, sir.
He is, first of all, he is victim.
Yes, yes.
His money, he has to, you have to give it.
Yes, yes.
ମୁଁ କରିଛି ନା ସେଟା ସେ ଅର୍ଡରଟା ଆନେକ୍ସ କରିଛି
And then,
22 ନମ୍ବର ନା page
Are you
22.
doubting that it is not his money?
No, I also reflected that he has no objection. Well, IO has stated that I have no objection.
See, come to page 13. He come to page 13.
yes, sir.
Learned counsel for the petitioner submitted that the IO has requested the learned SCGM Bhawanipatna by his office letter dated so and so for release of the freeze case
Aଜ୍ଞା.
From the amount of fraudster.
ସେ
In favor of the complainant.
IO prayer question, but court is doubting on
No,
the
no.
integrity of the IO, lordship. That order has been clearly mentioned.
He is the complainant.
Yes, sir. That
It is his money.
yes,
Take some undertaking, indemnity or something.
that's
Huh.
only denomination.
As it is, he is a victim, his money is
The learned
defrauded.
trial court said doubt the integrity of the IO on the basis of the integrity of the denomination variation. There is the variation of the denomination. Therefore, the learning trial court has come to hold
So
that.
take color photocopy and keep it. And give it.
Let it be issue notice also.
ठीक है?
After the instruction.
ठीक है, whatever you have seized, take color photocopy
Yes,
and retain that and give the money to.
my
Color photocopy of the all denomination from both the sides. Keep it and give it. Issue notice, huh? Next week, roko.
70,
This is how the burden of these courts are increasing.
Yes.
ଡିଫରେନ୍ସ ସେ କହୁଛନ୍ତି ମାନେ 14 ଲକ୍ଷ ଟଙ୍କା ହେଇଛି 13 ଲକ୍ଷ ଟଙ୍କା ସିଜ୍ ହେଇଛି ତେଣୁ ମିକ୍ସ ମ୍ୟାଚ୍ ହଉଛି ଇଏରେ ସେଥିପାଇଁ ମୁଁ ରିଲିଜ କରିବିନି ଦ୍ୟାଟ ଇଜ ଦି ଅବଜରଭେସନ ବାଇ ଦି କୋର୍ଟ
Yeah, but you have to give your indemnity bond what
ଆଜ୍ଞା ମୁଁ ଆଇ ଏମ୍ ରେଡି ଟୁ
and the color photocopy they can retain.
ଆଜ୍ଞା
What is the big deal about it?
ଆଜ୍ଞା
And videography also they can do it.
yes ma'am.
70,
My lordship, file this matter for passing of FIR against the petitioner. The petitioner on OP2, the informant, already divorced on 4/7/23. Order copy annexation number 1.
Yes.
They are living separately from since 25/19, as mentioned in the FIR by OP number 2, who is the informant. Copy of the FIR annexed as annexure 3. As they are living
I'll issue
separately
notice,
from
matrimonial issue notice.
But expert divorce is allowed by expert.
Expert, but has she has challenged?
No, sir.
That I have no idea.
She already
That-
filed.
that-
She already filed on divorce case and withdraw. After that, we are filed the divorce.
When you got an expert degree,
Yes, sir.
has she challenged that expert degree? No.
No, sir.
Okay.
She already filed, but she know that because she already filed one divorce case. After that, she withdraw the matter. When we are going for a child custody, after that, she filed this FIR against the family person and the petitioner.
Next.
item 80,
May I proceed? File this application to challenge the order dated 21/2025, rejecting the petition filed by the petitioner before the London court below dated 18/11/2024, sent the original check by the exhibit 1 along with admitting writing of the accused to the forensic laboratory for the handwriting expert. The case under section 138 in Act was registered against the present petitioner.
It's rejected.
rejected.
Hmm.
Both the petitioner and the opposite party, businessman, both are friends. Due to the security amount has been given, the issued a blank check to the opposite party.
Except impugn order, you have not filed anything. How will I know? What is the case of complainant? What is your case? How will I know? Except the impugn order,
Yes, sir.
whereby your application is rejected, you have not filed any document.
Xerox copy is there, so
Whatever you have to place on record, how will I know what is the case? Have you read Oriental Commerce judgment?
yes.
Have you read that judgment? If the signature is appearing in the check, if you have admitted, then this cannot be sent to
Forensic.
foreign. So therefore, unless you make out a case that signature is not mine, somewhere in the complaint or reply to the 138 notice, nothing is there.
I will file the document.
Now you withdraw it and file. Learn counsel for the petitioner seeks to withdraw the present petition to file a better one with
Yes.
better particulars and relevant documents. So otherwise, I'll impose
Certified copy maybe.
the certificate copy is written or written. File at least minimum document at least you file.
Xerox copy to me.
One page
But-
impugn order quasi. What is this? And it is not expected from you at least. You are such a senior and yeah. Therefore, I am not imposing cost. Will you pay it to the bar or will withdraw? Either of this. Withdraw and file. It's the same amount of money you have to spend. Give it to bar and file additional document. That's a better idea.
The return of the certificate.
File a better one. Yes.
19.
But you read that Oriental.
Yes, yes.
Oriental judgment. That judgment is against you. Yes.
May I please, your lordship?
Yes.
It's a very unpleasant fight between two lawyers. An advocate versus APP.
Hmm?
Plus unpleasant fight between two lawyers plus. And the advocate is the OP number 2 and the APP concerned Srimati Pratima Sahu has been added as the OP number 3. Initially, plus the complaint was lodged before the collector that the APP and the present petitioner is the sub-collector come STM Koptipada by the time the complaint was lodged.
He lodged and attacked the officer.
No, by making the false bill in the court as obtain the fees.
Certificates are being issued by the STM sub-collector as because the APP usually appears. So the advocate's contention is that certificates is being falsely issued in favor of the APP, and that's the reason was a complaint was lodged before the collector, and subsequently while that petition was pending, a writ application was filed before the Honorable Court, and by order dated 27/7/2021 at page 32 plus.
Page 32.
May I pray one thing before my
Yes.
my senior also. Here is a case arising out of a protest petition also. Subject to consideration. Notice to be issued to the OP also because here is a case initial FIR has been lost, the FIR is made thereafter the protest petition in this case is around. And my
What do you say? 32. What is this order?
Order is plus that is at annexure 9. Order of cognizance dated 7/3/2025.
No, what are you showing for page 32?
32 plus that is the order passed by the Honorable Court. That is order dated 27th July 2021, whereby the Honorable Court has directed for disposal of the representation that was pending for the collector Mayurbhanj, filed by the advocate concerned, OP number 2. And basing upon the same, the collector made an inquiry, and in inquiry it has been found. Your Lordship, come to page 35.
Yeah.
That will last paragraph. I am reading that paragraph. That the allegations against Srimati Pratima Sahu APP attached to the court of STM Koptipada Udola, the present petitioner, by the advocates who is submitting false bills for payment of remunerations is not at all true. Srimati Sahu APP has claimed the remuneration bills as per her attendance in the court of STM Koptipada Udola at the time of hearing and execution of PR bonds. After duly checked the bills being submitted by the APP Srimati Sahu by the bench clerk of the undersigned
with date-wise posting made in the court diary and case record.
Let us issue notice. Written on phone. Part number 2 and 3. Who is the 2?
Plus 2 is the complainant loss.
And 3 is the
3 is the APP loss. And once loss, the Lorent court below refused to take cognizance as because sanction was not available. And challenging that, the complainant came up before the Honorable Court again. And there, this Honorable Court has directed to dispose of that case.
anything has happened. Let us see.
Yes. Second time loss, cognizance is taken.
Move application. Let him move up.
Pardon me?
Application for adjournment be moved.
Adjournment?
Before trial court.
Yes. Yes. Because proceeding can be stayed loss.
No. There are so many things. So many times you have come to the High Court.
No, I have not come loss. I have come once loss.
Well, I'll examine it.
No,
It's not so simple.
I have got
You want to make it simple?
I have got a prime case. Can see.
Because collector has said that.
Even the judicial London magistrate below. You also can come to page 93. Order date 16/9/2023. 93 loss.
Yes.
Order date 16/9/2023. You also can see from the bottom portion I'm reading.
Yes.
After completion, you will get it just 5 lines from the bottom. After completion of investigation, the investigating officer submitted FRT in city 823/2020. They want to file a protest petition. The alleged acts have reasonable connection with the official duties of the accused persons, and there exists a reasonable connection between some of the alleged acts of the accused persons and the official duty of the accused person. Therefore, there is need of prior sanction of the government as contemplated under Section 197 of CRPC to proceed further in this case. As one of the accused is a government servant, he is now working as additional secretary to the government class. It appears that the protest petitioner has not obtained any prior sanction from the competent authority to prosecute the accused persons. Hence, the protest petitioner is directed to obtain sanction from the competent authority and file the same before this court so as to enable this court to proceed further in this case. Well, subsequently challenging this one, the complainant again, Arvind Kumar Patnaik, the open 2, file 1 CRLMC, that is 3094/2024. On the next page, page 95.
Yes.
There, he got an order citing a judgment of the Honorable Appeals Court that stands in my favor. And there, you also will get it page 98.
98.
Concluding portion of the order.
Yes.
Further, the matter is remanded back to the London trial court to re-examine the issue, keeping in view the aforesaid judgment of the Honorable Appeals Court. Additionally, the London trial court is directed to provide an opportunity of hearing to both the petition complainant as well as the accused person and proceed as per the direction of the Honorable Supreme Court in the above noted judgment. Now, you will only examine the judgment whether it is applicable to him or to me. And this person even...
Let the trial court do it.
And he did it. He did it. And
what does he say?
yes, plus that is at page 99. Annexure 9, staff Annexure 9.
Yes.
There I am agreed to loss. Page 105.
This is the impugn order.
Yes, boss. Yes. There was, I am reading
What does
this
he
court.
say? Sanction is not required.
This court, after the direction passed, plus I am reading page 105, 6th line from the bottom. This court, after direction, got it plus. This court, after the direction passed in order dated 28/8/2024, page 105.
Yes.
Passed in CRLMC number 3094 of 2024 by the Honorable High Court of Orissa, and after having satisfied on the basis of the facts, documents, and what are borne out from the statement of the complainant as well as the law laid down by the Honorable Appeals Court in 2015 to OLR Supreme Court 383, and after hearing the complainant as well as the accused person is pleased to pass the order. The court has perused the complaint petition, initial statement, and other documents in which a prima facie case for commission of offences and so on. So, hence cognizance of now
Sanction is not required.
Sanction is required, loss in this case. Earlier, the court was saying that sanction is required. Now, after getting the order from this court, the court said that sanction is not required. Direct taking the cognizance.
Let us see the judgment for Inspector Police.
Yes.
Show me the judgment.
Yes.
Which paragraph you are reading? You are appearing for complainant.
No, he's
Paragraph 5 also can Para 5 also.
I agree with the respondent, move the High Court.
Ratio.
Your Lordship, here is a case,
Ten.
in that case.
That is a- I'm vendor conspire करके issue करते stamp. That case is totally different.
ये करते misappropriation करते Lawrence trial court is
There is a case of misappropriation. Here he has only issued the certificate to the APP. As a token of proof of for appearance before me.
in case of present petition also.
I think it has to be stated because see there are two views now.
Yes, sir.
One is this court says that you reconsider. After reconsideration, he says that sanction is not required.
But if in the first case,
I understand it.
In the private complaint, the Lawrence trial court has
That's not the issue. Don't go here and there. Come to the point. Point is, earlier the court refused to take cognizance, saying that 197 sanction is required.
Yes.
That order was challenged before this court. This court, relying upon Inspector General, says that consider the judgment and pass an order. Now this order is passed, sanction is not required. This is what he is challenging. Right.
Sanction is required. Here is the case subsequently says.
Petitioner is saying the order dated 7/3/2025, passed by Lieutenant HDJM Udala in so-and-so, IT so-and-so, whereby cognizance of offences punishable under section 406, 409, 420, 468, 467, 120B and 34 IPS is taken against the petition. Mr. Kotugia, on account for the petitioner, submits that in the absence of sanction under section 107 CRPC, the court ought not have taken cognizance. This earlier the same court had taken in view white order dated 16/9/2023 that in the absence of sanction under section 197 no cognizance could be taken. The said order was essayed by the informant by filing CRLMC number 3094 of 2024 before this court. This court, by the order dated 28/8/2024, set aside the order dated 16/9/2023 and remanded back the matter to the trial court for hearing the same express, taking into consideration the judgment of the Honorable Supreme Court reported in so and so. Pursuant to the remand order made by this court, the trial court heard the parties and passed the impugn order, arriving at a conclusion that no sanction under 197 CRPC is required, hence proceeded to take cognizance of the offences. Issue notice, so. In the meantime, proceeding before so and state till next date. Yes.
20.
Yes. May I humbly claim us? If a lordship will come, my learned friend's name may be reflected along with me.
Yes.
Dr. Vinod Mishra.
Yes.
20.
The petitioner is challenging the order where warrant has been issued while he was in jail custody, your lordships. Here what has happened, this petitioner and the opposite party number 2 are husband and wife. They are indulged themselves into several litigations, your lordships, starting from 148 of...
The petitioner is the husband of opposite party number 2.
Yes, your lordships.
And who is opposite party 3?
He is the child born out of their wedlock. And another application under section 13 is pending, challenging the order under annexure 1, where warrant has been issued while the petitioner was in jail custody, your lordships. The lordship may kindly see page 12, your lordships. Page 12.
Yes.
That is order dated 11/7/2024. Petitioner is the wife here, your lordships, in a DV proceeding, your lordships. Execution in the DV proceeding. Petitioner file a petition to issue fresh summon to the opposite party through Superintendent of Jail, Soro, as the OP is in sub jail Soro in miss case number such and such, which is allowed. So thereafter,
Your jail in which case?
in another execution case, in execution case, as because the petitioner could not.
There is 2 or 3 execution cases.
5 execution cases, Your Lordship.
Wife, against the petition.
5.
You prefer
In
to
one
remain in
case,
jail?
he was inconstant.
He could not pay.
What happened to the DV order by which the maintenance order is passed?
That order was passed expertly. That was challenged before this honorable court in that is WPC number 12848 of
What happened?
2019. That was dismissed. That was dismissed and directed to file. But thereafter, this petitioner could not file.
That's right, but that main order stands.
Yes, that
Then
stands.
you have to pay. What to do?
No, he has to pay, but warrant has been issued time and again. Warrant has been
That's the
issued.
procedure. You will not be arrested, but how does it make difference? to you?
But he was then in the jail custody, Your Lordship.
Let it be. You're continuing in jail custody. How does it make difference? NBW issued or not issued?
Thereafter, he has been
You have to
released.
pay the money. The fact remains that you have to pay the money.
But now he could not appear before the executing court because the warrant is there.
The court take cognizance of the fact that you are in jail.
Yes.
Thereafter issues to NBW. How does it make difference to you?
Because
You
of
will not be taken into custody or you are already in the custody.
no, now he has been released after
Then again you will have to go because you are not compliant.
serving.
You have see, this is a perpetual thing, unless
Yes.
you comply.
But consecutively, court cannot keep the.
Show me any judgment or anything.
That has been observed in the judgment itself, Your Lord, order itself.
But you have to pay the money, that's all.
Yes, so that Your
What is the
Lordship,
amount? What is the amount due?
amount due is 41,000 some odd.
No, wherever you say that's what the amount.
That reflects in the order itself, Your Lordship.
Where is that? Where is that?
There is a order of 3,000 per month.
Where is that? You tell me the amount.
Sankar Mishra, Annexure 2, my learning friends annexed the order of the.
No, Paparosi, time and again he has served in
You
the.
tell me where have you said that what is the due amount? Come to the point.
Yes, Your Lordship. Due amount, Your Lordship, this application has been filed in 22 for 11 months. So it comes to around 43,000 some odd. I have not
Show me from
stated.
record. Show me from record.
Your Lordship, the DV order is under Annexure 2, Your Lordships,
Yes.
where direction has been made to pay 3,000 per month towards maintenance, Your Lordship. 2,000 towards maintenance and
How
1,000.
will I know when how much is paid? 2017 order.
He has not paid a single penny, Your Lordship.
2017 order.
Yes, not
Then
paid, not paid.
Calculate till 2025. How much it is? How it is 41?
No, for that period, for the present execution period, it is.
Where have you made an averment that this much I have paid, this much is yet to be paid? Anything, any averment made anywhere in the entire proceeding?
No, Your Lordship. I have
Then
not.
how will I stay like this? Main order stands.
Yes.
Execution is a consequence of that. Main order stands. You have not challenged and failed there. You have to pay. As simple as that.
Your Lordship, what I pray, Your Lordship, if the warrant is recalled, then I could appear and contest that.
Therefore, I am asking how much is it due?
That instruction.
50% you pay and go and appear. That's what I want. I am inquiring.
That instruction I have to take. How much he has paid?
Pass it over and tell me.
Yes, sir.
50% of the due amount to pay, I'll pass it and go and appear. That's what my inquiry is.
My humble submission, Your Lordship. He could not pay 41,000 when he was sent to the jail for the first time. So
The problem is then you have to be there in jail only. Because there is an order.
Yes, sir.
That order stands. It has to be executed. The opposite party number 2 is your wife. Opposite party number 3 is your son, who is 11-year-old.
Yes.
3,000 rupees also you will not pay.
But Your Lordship may call this
That's
matter.
the reason you failed in your challenge. And it has to be executed. What to do?
Your Lordship may call this matter next week so that I could take instruction as to how much amount is due.
Yes,
And
you pay, otherwise you challenge that and get that order set aside. What to do? After arguing for some time, the learned counsel for the petitioner seeks an adjournment to obtain instruction to instruction regarding the exact amount due to be paid to the opposite party. Is the matter. Yes.
21.
Obliged.
May I please, madam?
My lord, here, my lord, I pray, my lord, to allow my CRLMC application and set aside the order dated 21 to 25, passed by Learned Additional and Session Judge Kujang in appeal CRLA appeal number 2 and 25, arising out of 1cc case number 331 of 115, but thereby reducing the compensation amount from 20% to 5%, my lord. My lord, Annexure 1 is the order, my lord. Page 10, your lordship, may I read that, my lord?
Yes.
The last order, my lord.
Yes.
Till the realization of compensation amount is hereby stated, the applicant is directed to deposit 4 lakh, that is 20% of compensation amount awarded by the learned court below before this court in form of court deposit within 60 days, or else the order of suspension or absence, my lord. My lord, my father, I am now suffering, my father is suffering from spinal cord disease. That is an Annexure 3, my lord. Annexure 3, my lord, page 36 to 41. And there are, I have spent heavily on my father's.
Now you have been convicted.
Yes, my lord, I will deposit, but compensation amount should be reduced, my lord. That is 20% to 5%, I pray. That too, I have to deposit. That too, I have to deposit within 22 4 to 25.
How much you have deposited by now?
My lord.
How much you have deposited?
First time I have no, I have not deposited yet.
During trial?
During trial, I have not deposited anything, my lord.
I simply issue notice, issue notice. But you have to pay.
Yes, I will pay. I will pay, my lord. But 20% is 4 lakh.
Shall I fix the installment?
Yes, my lord. So 6 installments.
No, what 6? You are convicted 20 lakh.
No, my lord. No.
Why leniency to you?
Immediately I cannot pay, my lord.
If your conviction is upheld, then?
That will be problem, my lord.
Then immediately you have to pay?
My lord, I will pay that.
Your appeal is dismissed?
No. I will pay easy installments, my lord. No.
There is no innocence of presumption of innocence is no more with you. Now you have been convicted. You have to pay.
Yes, my lord. But installments, my lord.
I will issue notice subject to deposit up for 10%. 10% of check amount.
5%, my lord, subject to deposit.
Issue notice to opposite party number 2, subject to petitioner paying depositing 20% of 10% of the check amount with the appellate court, within a period of 15 days. Yes.
And that has to be paid, my lord, within 22 4 25.
I am giving 15 days, 10% you deposit, I am issuing notice.
5%, my lord. Then
next.
22.
The petitioner, the owner of the offending vehicle, the application for release of the vehicle has been allowed. Lordship, kindly class running page 14. Here, Lordship, the
cash security,
cash
3,50,000. You are the owner?
Lordship. The vehicle of the owner of the name has been mentioned in Jadunath Sahu, the petitioner. In the order, it is mentioned as Jadunath Vishwa. They are wrongly that I did not see question.
Jadunath Sahu.
Lordship, kindly glance running page 14, Lordship. 14 the release in favor of the petition, namely Jadunath Vishwa. The petition has been made running page 12, Lordship. Jadunath Sahu, but in the middle portion of the order that has been corrected by the court.
14, page 14, na?
Page 14, Lordship.
Yeah. Where does it say? Jadunath Vishwa?
In second. The petition has been in the second para, Lordship. In view
Jadunath Vishwa, who has corrected it?
That has been corrected by the court, not by me. Yes.
But who, whether you are Jadunath Vishwa or Sahu?
No, Lord, Jadunath Sahu, Lordship.
Jadunath Sahu was written. No.
Lordship, running page 12. Lordship, kindly glance running page 12, Lordship. Annexure 2. Who is the petitioner, Lordship?
But that's right, but it is corrected by the court.
It is corrected by the court. Wrongfully corrected. Instead
Then
of
it has to be corrected, otherwise,
otherwise.
then move application and get it corrected.
Now here also, in fact, Lordship, it was corrected. The name was reflected as Sibonath Singh. That has been corrected by the court. Jadunath Bisu instead of Jadunath Sahu. Not my part of fault, Lordship.
You have to get it corrected or not? You tell me.
Lordship, certificate copy ମୁଁ ଆଉ କେମିତି କରିପାରିବି?
You have to move application there.
Lordship.
Unless you correct that,
Lordship.
even if I pass the order, it is neither here nor there.
Now here, Lordship directed to release the vehicle in favor of the petitioner. That has been scrutinized by the
Who is
court.
the petitioner? Vishay or?
Sahu, Lordship. Sahu is the petitioner.
You see the order. Why don't you understand this? Is it a very big issue or what? You just you see the Vishay is written, handwritten.
At the time of consideration, they say they prior to
Go and
the
do an
vehicle.
application before trial court and get it corrected. Otherwise, you will be in trouble. I'll simply issue notice. Get it corrected. Otherwise, next time I will not do.
Lordship, the vehicle will be put in trouble. Lordship, the offending vehicle is kept in the open sky. Lordship,
Okay.
there is a
After 1 week.
the vehicle. Lordship, can you glance for a moment, Lordship? The application was allowed by the trial court, Lordship. There was an imposition of cash security of rupees 3,50,000. Where is the value of the vehicle is 3,90,000.
Where is the value?
Lordship, running page 14, Lordship. Can you glance?
14.
14. In the present case,
Value of the vehicle is mentioned in the current insurance
Lordship,
is 4,90,000.
3,90,000.
No, sir, 3,90,000.
Lordship.
Yes.
Since the insurance is renewed soon after the occurrence and the insurance company is competent to declare valuation, hence this court feels the same can be considered for imposing cash security and there is no necessity to call for a.
Are you an accused?
No. Lordship.
Are you an accused?
No, I am not the accused.
Who is the accused?
In fact, the vehicle was cleared by the driver, though the petitioner is the owner come driver, but at the time of occurrence, he was not playing the vehicle.
Gas diving, due to that one person has died. The informant's father died.
Okay, cash security, property security, let him be right. Petition is agreed by the condition imposed by JMFC, Orissa, while allowing the application of the petitioner under section 457.
Lordship, 457.
Now 503.
Now.
BNS. 503 BNSS bracket 457 CRPC. CRPC releasing the vehicle. Releasing which vehicle is this?
Vehicle is what? Bearing registration number, Lordship.
What is which vehicle? Which vehicle is this?
And the running page 13, Lordship.
Tell me the vehicle name.
Name, Lordship. This is the one truck, Lordship. Bearing registration number OD05A.
Ashok Leland vehicle. Bearing number OD05AN 1605. 05, whereby the court below has imposed a condition of furnishing cash security of 3,50,000. 3,50,000. Then also the petition submits that the value of the vehicle as per the insurance paper is 3,90,000, which has been recorded by the court below. However, while releasing the vehicle, the petitioner has been directed to purchase cash security of 3,50,000. He agreed by the same and opposed the spot. He further submits that the vehicle, you are not the driver.
No, Lordship.
The vehicle is got entangled in Orissa PS case number 826 of 2024 for alleged offences punishable under section 281 and 106 bracket 1 of BNS. The petitioner is not accused in the same. Who was driving the vehicle?
They will be engaged by the another person.
Engaged a driver who got entangled in the case due to interest and negligent drive. The petitioner moved the application for release of the vehicle. Although the by impugn order, the trial court has released the vehicle, however, imposed the owner's condition for cash security for 3 years and 50,000. Okay. And the counsel for the petitioner submits that he would be he would comply all other conditions as have been imposed by the court below, and also furnish indemnity bond when the property security to the tune of 3,50,000 regarding that to the statement made by the petitioner के बाद the condition imposed by the court below for depositing the cash security of 3,50,000 is modified to the extent that the petitioner shall furnish cash security of 2,000 amount and a cash security of property security of 3,50,000 and also furnish and need to fund up to equal with this modification in the petition. Yes.
Okay.
23. The petitioner seeks to quash the order dated 4/3/2025 passed by the Law and Session Judge Noapada in Criminal Division 1 of 2025, my lord. In dismiss and confirm the order dated
May I, before my learned friend starts, page 11, this is the affair of some other case. This is the different from this case.
What have you filed, sir?
ବର୍ତ୍ତମାନ ଥାନାରେ ହାବିଲଦାର ଭାବରେ କାମ କରୁଅଛି। ସକାଳେ ପେଟ୍ରୋଲିଂ କରୁଥିବା ସମୟରେ ସମୟ ପ୍ରାୟ 5ଟା ସମୟରେ ମୁଁ ଖବର ପାଇଲି ହରିଆର ରୋଡ ବେଲ କି ଛକ ଜଳାରାମ ଛକ ମଝିରେ ଦୁର୍ଘଟଣା ହେଉଛି। ମୁଁ ତୁରନ୍ତ ଘଟଣାସ୍ଥଳରେ ଦେଖିଲି ଗୋଟିଏ ଟ୍ରକ୍, କିନ୍ତୁ the case is different. There is 2 persons assaulted to each other.
Just check it up.
Next week.
Check it up. Completely.
25.
Petitioner seeks an attorney to verify the document which he has filed. Apparently, he has filed with the petition. Apparently, the FIR included with the petition is a different FIR. Different FIR.
May I please, Lord, sir? May I please, Lord, sir?
24, 25.
May I please? The petitioner prays for an appropriate direction may kindly passed by Lordship for appropriate expeditious disposal of the 1cc case number 15 of 2024 pending in the court of the law in JMFC City, Cuttack. What happened, Your Lordship? The petitioner is the complainant in 1cc case under 138 of NI proceeding. The case is at the fag end. Case is posted for accused evidence. Your Lordship, kindly see the annexure 3 series page 29. Page 29, annexure 3 series. Evidence was closed on 24/1/2025. Accused statement was completed, and 10/2/2025 was posted for evidence on behalf of the accused opposite party. Since that date, they have been repeatedly taking arguments with on frivolous grounds. Till now,
What repeated is 2 dates only.
thereafter is there. Thereafter is there. Thereafter is page 30. Page 30 is there. Say order dated 7/3/2025. Now order dated 19/3/2025. Now its case posted for 23/4/2025.
3 dates.
4 dates. Different. Prior
Petitioner is the informant in IC 1cc case number 15 of 2024 or 2024. He seeks indulgence of this court for a direction to the trial court for expeditious for the complaint case initiated by him under section 138. Taking me to the pleading sheet of the court below. And counsel for the petitioner submits that on 24/1/2025, the complainant has closed his evidence and the statement of the accused is under section 330 CRPC was scheduled to be recorded. However, the counsel for the accused, it is opposite party, has been seeking adjournment and the trial court has been accommodating the accused. In this process, one, two, the full adjournment has already been granted to the opposite party accused. Hence, he seeks an to the trial court for expeditious conclusion of the trial of the case. Needless to say that the section 143, bracket 204, provides for disposal of compensations under section 138 with an appeal of 6 months. In the present case, the trial is vacant. Therefore, the trial court shall not be lenient in granting adjournment to the accused, but accused with cost of delay to proceed. And hence the prayer made by the petitioner desires merit according to the same is allowed. The trial court is directed to do and to see that the trial is concluded without unnecessarily granting adjournment to the accused or the petitioner.
I pray your lordship, stipulated period can be
No. It is vacant. Yes, next.
26.
May please, your lordship. The petitioner, your lordship, is the order dated 5/3/2025. Thereby rejecting the recall petition of the petitioner to recall petition PW 1, 2, and 3, 4, where examination chief was there, but no cross examination was there.
Where are the testimony? Except impugn order, you have not filed anything.
Let's see, no questionnaire is there.
What is the application under 311?
300, let's say, not a single question was put forth.
How will I know? Neither the deposition filed nor the application filed, except impugn order, you have not filed anything.
This case of a
No,
POCSO.
for the petition seeks in 1 week adjournment to place and record additional document to substantiate the case. Please the matter.
27.
Let the account of the petitioner was debit free, your lordship, in pursuant account by the direction of cyber crime Vijayawada, my lord, Andhra Pradesh, your lordship. The present petitioner is resident of Sundargarh district, your lordship. He is running a shop by using QR codes. Twice amount has been deposited in his account, your lordship. Once the amount is 7,553 and another is 21,763. That is on 11/12/2024 and 9/12/2024, your lordship. For that, your lordship, the account of the petitioner was debit free in pursuant to the letter issued by the opposite party number 1 to the opposite party number 2, that branch manager.
Who is freed your account?
My lord, Police Commissionerate, Vijayawada City, Andhra Pradesh.
How can I pass the order? You go to that court. Freezing has been done by Andhra Pradesh police. What can I do? Merely because your account is here, it doesn't mean that I'll exercise the jurisdiction. You have to go there.
I'm also resident of your lordship.
Maybe the case is pending there.
Against me, no case has been registered, your lordship.
I don't know because the Andhra Pradesh police has seized your account. I can't exercise my jurisdiction. There may be some case, there may not be some case. How do you know? How do I know?
My lord, I pray your lordship, the amount has been deposited in my account, my lord.
Why don't you understand? You have yourself have filed the annexure. They see all Andhra Pradesh police has done it.
Lord,
how can I exercise jurisdiction?
I'm the resident of my lord Orissa, Sundargarh district, your lordship.
If you are a resident of America, America court will do it. What are you talking? 482 jurisdiction, how can I exercise there in Andhra Pradesh? No, let come to the petition.
My lord, next week, my lord, I will. Assume.
You will take Sundargarh to Andhra Pradesh,
No.
or Andhra Pradesh will bring to Odisha. You tell me, accordingly I'll proceed.
Assume, but assume.
What will you do after 1 week? Like, why it will be pending unnecessary? You have to resort to the right remedy. This court, how the court will assume jurisdiction? If something happened in the Andhra Pradesh, you have to go to that court. Wrong, right, whatever.
My lord,
What can I do?
Understand that it will not be.
Satisfied himself. No, he is satisfied, but he is such a senior person. He knows it. He knows that he doesn't have the case. That's it. He doesn't have an answer to that. And see who you infiltrated, the bank people. How can I give the direction to the bank? Police, there is a case against you. And
no case against me, your lordship.
Just see the notice. The
notice was issued to the bank. And bank has reached my account.
Do one thing. You give representation to the concerned police station.
Police has not directly issued notice to me or anything. Bank issued notice to me that in pursuant to the direction given by the Andhra police, I have free.
That is what happens. If a suspicious transaction takes place, some cyber crime offense is registered there, the police generally give it to the bank. Please freeze it.
My lord, police has not.
Till the inquiry is going on. After inquiry, investigation, they may release it also. We don't know what kind of cases registered against you. See the annexure 1 which you have filed.
My lord.
Notice under section 94 and 10 of BNSS.
My lord, that has been issued.
And all the IT Act and cybercrime Vijayawada is investigating your case.
Issued to the bank, your lordship. That letter has been issued.
That's right. The cybercrime Vijayawada police station is investigating the case. And from there was a letter to the bank.
My lord.
As a result of which it was freezed.
My lord.
So unless we inquire from Vijayawada police, I can't pass any order. Okay, you withdraw and do returns. Then comes about the petitioner seeks to withdraw the present petition to resort to the right remedy available to him under law. Write a letter to the SHO Cybercrime Police Station, Vijayawada City.
He has written letter.
Ask him why have you
already he has written letter.
Write a letter immediately. Thereafter you do something. Then you resort to writ jurisdiction. 28.
Please, my lord. Challenging the order of additional session judge, Hon'Ble, my lord, in the 130 NA Act, my lord, under 130 Act, he is convicted. After he has been convicted, my lord, the
130.
130 NA Act, my lord.
Yes.
He has been convicted, my lord. The petitioner compensation amount to allow to deposit less compensation amount as ordered by the Lord and Court below, my lord. Only page 15, my lord, kindly see. Page 15.
Yes. Yes.
This was after issuing appeal or application admitted the appeal.
20%. Court has directed you to deposit 20%. 148.
10%, my lord. I'm ready to deposit 10%, my lord.
This is not a routine petition that 20% is that you come to the court. Yeah, you have to make out a case by prima facie you have a case.
In the meantime, Lord, LBW has been issued, my lord.
Obviously, if you don't pay, then
Annexure 5, page 24, my lord.
20?
24.
You take
10 to 2025.
Do one thing.
My lord.
I will stay the NBW subject to payment of 10% and go and appear before the court and move application. Right.
Yes.
Petitioner is agreed by the order dated 14/2/2025 passed by Additional Sessions Judge Anandapur in Criminal Appeal number 10 of 2024, whereby the petitioner has been directed to deposit 20% of the compensation amount, under section 140 is for NI Act. Petitioner has been convicted, by which court?
JMF Sandapur, Narav. No, sorry, SDJ Mandapur.
Hmm?
SDJ
Where is that
Mandapur.
order? Petitioner
Annex
has
H.
been convicted by the learned SDJ Anandapur by its judgment dated 27/9/2024 and direct him to pay compensation to the tune of 36 lakh, besides other sentences. The petitioner preferred in criminality against the state commission sentence order being criminality number 24. The appellate court by imbue order dated 14/2/2025 directed the petitioner to deposit 20% of the compensation amount. Since the petitioner has failed to deposit the compensation amount, therefore NBW, the court of SDJM Anandapur has issued NBW against the petitioner by order dated 10/2/2025. 10/2/2025. Agreed by the state order, the petitioner has opposed the score. The petitioner is citing the financial difficulty he's facing at this stage to make good the payment as has been directed by the appellate court. Therefore, he seeks leniency. Regarding to the submission made by the petitioner, the order dated 14/2/2000. The petitioner is directed to deposit 10% of the compensation amount instead of 20%. Subject to making good the 10% of the compensation amount, the NBW issued against the petitioner on 10/2/2025 shall remain stayed. The petitioner it is open for the petitioner to appear before the appellate court and move for appropriate application for variation of the order dated 14/2/2025. Such application move, same shall be considered on its merit. With this observation, the petition is for yes.
10% check amount though.
I've done it.
Check amount.
I can't change the law. I can't change the law. That's the legislation. What will do? Yes, next.
29.
Yes.
Impugns the FIR against me, setting the criminal law against me. No case made out against me at all. I don't know, kindly take run page 29. The beginning of the FIR.
Yes.
There is a request made to me, my lord, by my friend, Mr. That he will be available. He's here. I thought that was.
He's here.
Madam, kindly take on page 30.
33?
Yes.
Yes.
Information has been received by the group general manager, region rule, limited PSC, Ministry of Heavy Industries, Chanchal, so on to so and so. He is indulging in corrupt practice, activities in matter of awarding work orders, bills in lieu of obtaining advancement. It is also informed that Bridget Group was awarded tenders relating to civil construction work from Nalco, limited in location Ramanjodi and Vishakhapatnam, which was further entrusted to Penta Studio Private Limited, having its registered office in Commercial Place, Esplanade, Kasaragod, Orissa, Bhubaneswar, Orissa, is further informed that on 6/12, Chanchal asked Santosh Maharana, director of Penta Studio in plot number 2 and so, that his father, Monomohan, will come and meet him in his office for discussion in urgent matter. It is further informed that Santosh Maharana and Sri Chanchal Mukherjee at his Bhubaneswar office on 6/12/2000. This was the source information. During which Sri Chanchal Mukherjee demanded undue advantage / bribe of 10 lakhs from Santosh Maharana, which was to be delivered on 7/12/2024. This was the source information. In pursuance to the same, Chanchal Mukherjee promised to adjust the amount in the future meeting. Therefore, my lord, it's an adjustment, not a gratification for his purpose, my lord. It will be adjusted in the future meeting.
Yes.
It is further informed that Manmohan is scheduled to meet Chanchal in regard to in this regard sometime in the afternoon of 7/12. The above omissions and omissions of Chanchal Mukherjee, public servant, and Santosh Maharana.
Who is this Chanchal Mukherjee?
Chanchal Mukherjee is the area general manager of Bridge and Roofs.
Group general.
He is the one who is the person who is the liable under the PCI. 6, 7, 8, 9.
Where, what is your name?
I am not named in the FIR.
Okay.
I just finished.
Shyam Mahapatra.
Yes.
Yes.
That the above omission is the commission of Chanchal Mukherjee, Mukherjee and Maharana so and so, and other unknown public servants and private people disclose commission of a cognizable offence under 7, 8, 9, 10.
Yeah, what is it now? The charge sheet has been filed.
No, my lord. It is in the embryo stage. My lord, I'll just say. Then, my lord, Prevention of Corruption Act under so and so. My lord, may kindly then take how I come in, my lord. Page 37 onwards, page 39.
Yes.
Is the observation.
The observation, my lord. My lord, I'll take my lord first to 37.
What is this document?
My lord,
This document
memo.
this is the observation cum recovery memorandum.
Okay. Yes. 39.
Yes.
Yes.
37, my lord,
37.
can take. Office of Chanchal, what is the place, my lord? What is the date? 7, 8, 9, 10, my lord. Case registered under. My lord, case has been registered. The FIR has been set into, the criminal proceeding is set into motion, my lord, on 7.
Yes.
On at
11
source
o'clock.
information at 11 o'clock.
In the morning.
The morning 11 o'clock it has been registered. Place of the memorandum in the office of Chanchal Mukherjee, Group General Manager of Mediation Group Limited, East Coast Journal Office, so and so. Name and designation of these are the people who are witnesses, my lord, not very important. My lord, then, my lord, may kindly see the people that are there.
CBI.
Gurvinder of CBI. Gurvinder, Arjit, Suraj, Devendra, Rajesh, Akshay, Ashok. Today on so and so on the basis of source information, case under section so and so is registered as registered. Chanchal Mukherjee, son of late so and so, having permanent address of so and so, Santosh Kumar Maharana and Manmohan. Penta Studios is their company,
Maharanas.
the Maharanas. Unknown public and private persons. It is alleged that the group general manager of Bridge and Roof under the Ministry of Heavy Industries, Chanchal Mukherjee, son of late so and so of Jharkhand, is a permanent resident of so and so. He is indulging in illegal and corrupt practices of awarding work in lieu of obtaining advantage, undue advantage. It is further alleged that Vision Roof was awarded tenders related to civil construction of Nalco in aluminium in Jamanjori and Vishakhapatnam, which was further entrusted to Penta, a private limited company on so and so day, to Penta. It is further alleged on 6/8/2012, Chanchal asked Sri Santosh Marana, director of Penta, plot number so and so, and his father Manmohan to come and meet him in his office for discussion of urgent matter.
Your role is explained at page 40.
Yes.
Come to page 40.
39 first it begins, madam. 40.
40.
Madam?
The above said CB 18.
Yes.
And independent witness followed by the Hyundai Creta.
Yes.
So were traveling together. Then Chanchal Mukherjee alighted from the vehicle and the forest.
Madam, I just place the previous page, only for purpose of clearly making out the matter, understanding the matter. Madam, can you reach page 39? I'll begin with unknown persons. Then, madam, this will be same as the FIR. All these things go on the basis of the FIR. The source information
Page 30.
informed, paragraph 39. On 12/7/12, Santosh Maharana of Studio so and so at about.
You are posted as what?
I am adopted saying that after the completion, he gave it.
What are you?
I am a contractor independent of all these people, my lord. I am a contractor, a special class contractor. They make out a case against me after my arrest, though they show me as arrested on 7 in the spot of a particular place, they show me on the arrest really, my lord, on the next day.
You want to protect Chanchal Mukherjee.
That is what.
That's the legal.
That is valid.
That's the legal.
Yes.
You are a contractor, you wanted to protect him.
His interest.
So you waited that the Mamma Mia cafe
yes.
and the people came and
Yes.
I've seen it.
Yes.
I've seen it.
Yes.
Yes. So that's now investigation is still going on.
Yes.
At this stage you have come.
Yes.
Why have you come at this
My lord,
stage?
I have come at this stage because of the fact, my lord, there is no material against me under 7. I am not even a 120 deal. The conspiracy.
So far.
Not yet, my lord. Not so far. Not yet. And will never be, my lord. On the face of the FIR. And FIR doesn't name me. Even the arrest, my lord, may kindly take the arrest memo. Very interesting arrest memo, my lord.
Starts at page 46.
Before I take that, my lord,
40.
may I take, my lord, to page 43, my lord. 43, my lord. Third paragraph. In the presence of witnesses, Devadatta admitted that Chanchal Mukherjee had requested him to keep 10 lakhs for some time with him in safe custody. Thereafter, he will obtain the said amount from Devadatta. He will take back the money from him.
No, your role is there.
Yes, this is
the end. You came out with that jerry bag and from the
Yes.
and went to the Mercedes and kept it.
But the Mercedes, interestingly, Mercedes has not been seized in the seizure list.
So all these things are at very nascent stage.
Yes, my lord. This is the case stage at which my lords can interfere to find out. Because my lord, when we see the anomalies, my lord, I will demonstrate the anomalies. They have to file a response, my lord, because it is an imperative, my lord. My lord, may kindly see thereafter. And so, my lord, now there is no meeting of mind with me as far as 120B is concerned. Now 96. What is the section?
61.
No meeting of mind prior to this. I am a chance person who came in there, and for the purpose of this, he gave it to me. My lord, may kindly see the next page, my lord. The arrest memo.
You are with that Chanchal.
I was not Chanchal, my lord.
The money which was given, that money was given to you. You took it and kept it in another car.
Who gave it?
The witnesses have seen. Just see the page.
No, nothing.
Come to page 41.
My lord, who has given it? Not clear at all, my lord. I'll take my lord to the arrest memos.
When the local police directed the Devadatta and he opened the door of his Mercedes car,
Yes,
Then
sir.
in the presence of independent witnesses, Devadatta Mahapatra took out the yellow and red color bag,
Yes, sir.
having impression as hotel Vishwa something, Vishwa
Yes,
so
yes.
and which was handed over
Yes.
to him by Chanchal Mukherjee.
Yes, my lord. By
Chanchal
Chanchal
Mukherjee. And
Mukherjee.
handed over the same to the independent witnesses. Both the witnesses took out two blue packets and sealed the sellotape and so on, so on, so on. This bribe money has gone to your car and that is
Yes,
recovered
and
from
that
there.
car has been seized, my lord.
All these things are at this stage of investigation. How can I?
No, my lord, there's more to it, my lord. My lord, there's more to it, my lord. I am only stating that the conspiracy developed and ended. The right, I will demonstrate to my lord.
Maybe in the charge sheet you will be exonerated. How do you know?
No, my lord, may kindly see, my lord, may kindly take this.
Arrest.
Arrest memo, my lord, page 49.
46 to start.
It starts at 46. My arrest memo, my lord. My lord, may kindly see when I am arrested.
Am I empowered under 482 to evaluate every case diary to decide whether a case is made out or not unless it culminates to a charge sheet?
No, my lord. My lord, it is very.
And you may be having a good case. They may ended up filing a closure report, and they may not. They make you and you may be a witness. Who knows?
My lord, the law is no more restricting, my lord. My lord can nip it at the bud because setting the criminal law in motion.
And reading up the investigation, if prima facie is not made out a case, I have to analyze. Things are recovered from your police.
Their documents. We are not reading anything
I
else.
see their documents and prove, my lord, that.
Not a single
Let me
document.
understand what is the stage.
No.
Yes, Mr. Naik.
No, arrest me.
My lord, kindly take the arrest. See the arrest memo, my lord.
He was arrested. Lordship, am I audible?
Arrest memo.
It's the most important
My
document.
lord, kindly.
No,
see
that's
the-
here.
Am I audible, Your Lordship?
Because it's the arrest that connects me.
That is the arrest only that connects me, my lord, to the.
Lordship, am I audible?
The arrest memo at 49.
Yes.
Your Lordship,
Yes.
am I audible, Your Lordship?
The further informed that Sri Manmohan Maharana scheduled to meet Chanchal Mukherjee on 7/12/2024. Sri Chanchal Mukherjee and Santosh Maharana have been apprehended while accepting and delivering the money. Where am I there, my lord?
49.
49.
I'm there, but see,
Yes.
I'm there exactly.
First paragraph.
So therefore, who was accepting the money, my lord? The transaction was over according to the prosecution itself.
Maybe you are a potential witness.
Before trial, Your Lordship, sir wants you to evaluate evidence and do a mini trial.
Potential witness.
I'm not. I've been arrested for what, my lord?
It is seized from you.
What is the FIR? What
It's
is the
seized
FIR?
from your car.
Yeah, no, my lord.
Car has never been-
seized, my lord. How can this? How can the seizure not be there on the car, and how can they seize the material, my lord? It's a very serious, absolute. Like I mean, my lord, it's absolutely perfectly only for the purpose of harassing me.
Your
And
Lordship,
therefore, the fundamental of abuse of the process, my lord.
Your Lordship, he was arrested on 8/12/2024.
Yes, at what time?
Your
At what
Lordship,
time?
8/12/2000. Your Lordship,
Can I see what time they were arrested?
Your Lordship, 8/12/2024, he was arrested. It took 120 days to.
My lord, kindly see page 49.
220 days, Your Lordship, to file the CRM.
Are you on bail?
Yes, I'm on bail.
Yes.
My lord, my lord, kindly.
After 4 months, Your Lordship, they realized that no case is made out.
If you come to page 49, I'm there.
Yes.
Why arrest?
Yes.
Yes.
Why arrest? You just see number 2.
Yes.
The bribe amount of 10 lakh were recovered from his Mercedes car and which is delivered by Santosh Kumar Maharana to Chanchal Kumar.
My lord, therefore, Santosh Kumar Maharana is a private person and I am a private person, my lord. If they are saying that, but how does it read with, my lord, the previous paragraph?
That's what I'm saying. You can be a potential witness for
Yes, I
prosecution.
prepare to be a witness. Let them make me a witness.
They may do that.
No, let them do that.
Yes, Mr. Naik.
Oh.
I think he's a potential accused, Your Lordships. Let me argue.
So there-
Yes.
there-
He is an accused. Your Lordship, I'll explain. Your Lordship, sir,
My
actually,
lord, that page for 49.
Your Lordship, actually, the accused might not have told sir what he has done.
Why arrest?
Why arrest, my lord?
Yes, there I am there.
Yes. My lord, yes. Devadatta has been arrested on the spot. My lord, may kindly see that. On the spot on which day, my lord?
7.
7th. My lord, may kindly see the
Seventh
arrest.
evening at
Seventh
Mayfair.
evening at
Mayfair.
Mayfair, my lord. My lord, may kindly see the arrest memo when they have shown me arrest at page 10, page
46.
46. My lord, may kindly see.
46.
They are CBI, my lord, and 10 lakhs of rupees from a person of who is a special class contractor who is crores of rupees of work, and not with bridge and roof. My lord, may kindly see the arrest memo.
Sir, crore rupees, why you was accepting 10 lakh rupees?
My lord, may kindly see page 46
46.
last. Date and place of arrest. My lord is saying that I arrested on 7th. My lord, may kindly 7th, that is what he is saying. On 8/12/2000, about 11:40 in the office of the general manager, bridge and roof, India, in East Coast Zone office.
Where are you reading?
My lord,
46, serial number 10.
10.
46, serial number 10. Same document. Same arrest memo at one point says.
Absolute abuse, my lord. My lord, may kindly see when he is himself saying that I was arrested on the same day, and here they show me on the next day at 11:40.
Your Lordship, Your Lordship, I'll explain if Your Lordship, sir, the accused might not have told sir what he has done. Let me explain, Your Lordship.
Where have you arrested him? That in Mamma Mia cafe or in the office on 7th or on 8th? What is the case?
Your Lordship, I'll produce the case date. Your Lordship can peruse it because Your Lordship.
Because they have a case. You say in the arrest memo that is on 8/12/2022 at about 11:40.
Your Lordship, with due respect, that doesn't take away the culpability or criminality of the commission of the offence. Your
Yeah,
Lordship,
maybe, may not. You may be.
Your
But
Lordship, I'll explain what he has done. In 2 minutes, I'll explain, Your Lordship. Sir argued for 15 minutes. In 2 minutes, I'll explain what he has done. Time and again, sir is telling that he hasn't done anything. What is the relationship of Chanchal Mukherjee with Devadatta? Special class contractor. What was he doing in his car, Your Lordships? What is the relationship? He must explain.
There you are correct. There you are correct. It needs to be investigated.
Yes.
It's not so simple. Because 10 lakh rupees, somehow it was taken. There may be a lapse
And
of.
another person, Your Lordships, another IS officer, I don't want to name him, another IS officer staying in Forest Park.
Me to say that the
another IS officer.
Coercion.
You tell me, Mr. Naik.
Yes.
You have argued this matter in some other matter.
Yes,
Your Lordships. Because in that matter, they did not get released. They have filed another petition, Your Lordships.
Different cause of action.
Huh?
That's matter, my lord, where matter that.
For production.
Your Lordship, I can't give it because
Different
Same matter.
But this is quashing, that is production against production of
Lordship, give me 2 minutes time because
when that matter is coming up?
No
after 8th, Your Lordship. After 8th, Your Lordship.
11.
Give me the number.
11.
I'll issue notice and tag with that.
Yes.
Issue notice
But
and
Your
tag.
Lordship, Your Lordship, I need 2 weeks time. I'll file a detailed reply in this matter.
Yes, definitely file the reply.
Yes.
And clarify this position.
But
There may be some inconsistency in the arrest memo and all. On that basis, can the FIR be quashed like this?
I'll convince that my lord.
Procedures, Your Lordship.
Some with the difference. Maybe it is absolutely wrong entry.
Absolutely.
Procedures.
This is not,
Can it
this
be
is
a ground?
repeated thrice
3 times, my lord.
in the arrest memo, not
Okay,
just
let
one
him-
place.
Lordship,
No
let him
typographical error.
Their cases and
There
cases.
is an inconsistency.
Bhajanlal has clearly said, my lord. Their cases and
No
cases.
Bhajanlal. Bhajanlal is not applicable.
Well, how will you get out of the
No,
fact
Bhajanlal.
that the 10 lakh rupees changed your hand?
Yes.
From Maharana?
Yes,
there is nothing. You are the intermediary. Intermediary.
Yes, I will explain that. I'm not an intermediary.
I'm still saying that you can be a potential witness
Yes,
for them.
I'm supposed to be a potential witness, but they've arrested
For
me.
them.
And again, my lord, the IS officer, what they're talking about.
Your Lordship, he was arrested in December. Your Lordship.
Okay.
10 lakhs of rupees.
Your
why
Lordship,
is
he-
I'll reply. Let us. Okay.
Deep level error.
Your Lordship, no entry.
Give that number.
Again,
Issue notice.
347 of 2020. CRLMC 347 of 2020.
Your Lordship, there is no interim order.
No. What can you? No entry.
Yes, Your Lordship.
He's on bail. What to do?
Yes, Your Lordship.
We are
Yes.
not asking for
But I'm very sure my learned friend knows the law better than I, being my so much younger to me, and he also is a very fair counsel. I mean, he's an extremely fair counsel, my lord. I totally depend on him to be fair, and he will be fair, my lord. If I don't have a
He-
case,
he
I'll
will-
bow down.
He will suggest his client rightly.
I'll bow down, my lord, if I have no case.
Yes.
What's there?
I may be permitted, your worship. The item number 4, I was not here. And when I arrived into.
Item
inside
4, somebody is withdrawn. Yes, withdrawn.
Yeah, item number 9, sir. 4, item number 6.
You decide which item.
Yes, item number 6. I am wrong.
Things,
what happened? Your
I
lordship-
simply adjourn for 1 week. Today it may not be
No,
possible.
what happened? That the last occasion, the.
I can't go in reverse way. Please.
I have already filed the amendment cost title. And by impleading the person who is creating all sorts of disturbance about the shoot land, and I have already been evicted by.
It is so important, you should have come. I can't go in reverse way. See, we are at item 20.
No, your lordship may kindly the issue notice against.
Short date, they will take. Short
So
date. Yes.
that's next week, your lordship.
Yes, next,
week?
yes, next week. Yes.
Okay.
Yes. Tell me immediately. Yes.
Immediately dated 27/1/2021, my lord. Bail, my lord, 15/7/2009.
1,000.
31.
1,000.
NBW issued my lord 5/2/2025. Bail was granted 3/2/2020.
Okay. 5. Yes.
32.
Incident 32, NBW issued on dated 20th January 2016. Your lordship.
जोर से कौन पीके?
20th January 2016, NBW issued. And,
2016.
Yes, your lordship.
Yes.
And the person arrested on spot, forwarded to the court, then he is released on bail in the year 2004, your lordship. I don't have.
Do you have the date?
No specific date, I don't have.
1,000.
33.
Your Lordship. My lord, NBW issued on 6/2/2025 and he is on pre-arrest bail on 16/8/21. One more submission, my lord. My lord, the present this is a case of 376 filed by wife against the husband, my lord. The opportunity of hearing is not given to husband, that he is not known the
That is,
factor. Only a single chance of argument.
You have to tell there. It is only NBW.
But I also make from the
That I can't do.
only a single chance.
That's not.
One date for place my argument.
Just
only.
check it up.
My lord.
Yes.
My.
34.
May I please, my lord? Bail is granted on 14/5/2024. NBW issued on 6/1/2025.
500.
35.
Petitioner was on bail on 6/8/2019. NBW issued 7/2/2024.
36.
Recall of NBW, my lord, 2011-2024.
Bail?
Then 9/12/2019.
2019.
19.
37. 37.
37 your lordship, MW issued on 18/4/2019. Bail ଯାଇଥିଲେ 7/2/2019 ରେ 99 your lordship. 19 ମସିହାରେ ରିଲିଜ ହେଇଥିଲେ, MW ହେଲା 18/4/19 ରେ। ଏଥିରେ ଟିକେ difference ଅଛି। Initially, the petition was released on bail before the filing of the charge sheet. Charge sheet has been filed in higher offense, 376. Lordship, switch that.
May I please, madam? In the meantime, we came to know that the file has become dormant. So say nowhere about the file. The learned trial court JMFC is saying that we don't have the file, as the matter has been converted to 376, we don't have the power. Now where neither the sessions court or ATJ, they don't have any file. So my prayer submission that make the state to take the instruction where the file, where about the file. In the meantime, I filed the IF for not to execute the NBW. The third time I am coming before this court.
Se release ହେଇଛନ୍ତି 99.
Then simply I'll issue notice.
Yes, sir.
I is there.
Yes. Yes.
38.
May I please, your lordship? My lordship, last occasion, my lordship directed me to satisfy this honorable court. Why the
This matter has come to me.
38, my lord.
Huh?
This was modification. Modification.
Modification of what?
Modification.
My lordship, that my lordship granted me bail by the order dated 25/9/2024. Then kindly, sir.
Yes.
Then my lordship, I am submit that order for releasing for the purpose of bail. Then my lordship, London trial court neither decide my case nor reject my application. Then simply wrote a request letter to this honorable court that to clarify the order. Request to on director issue a simply request letter to this honorable court.
Who has given request letter?
That on London trial court, my lordship.
Where is that?
That my lordship file in my IA number.
Antecedent.
I know, I understand. Where is that letter?
Sir, kindly. Sir, let me clarify, sir.
Yes.
Sir, kindly have a glance in my IA number 1434 by 2024, page number 12. Start from page number 11, my lordship.
Yes.
After seeing all the things, my lordship directed me on dated 28/11/2024, my lordship, to file antecedent details and the status of the antecedent. Then, my lordship, I am filed the antecedent details, that is at flag Q, my lordship.
Where is that letter? Yes. Where is that letter? Where is that letter? Letter is there?
In attached with my IA, my lordship.
No, officially the letter has come out. It has been,
Accused
the
affidavit.
trial court has said that the letter has been issued. Where is that letter? Locate the letter and see.
My lordship, I want the certified copy.
No, it has to come officially. There is a judicial order to that effect. Let's see, by the order dated 7/10/2024, the letter additional sessions from special judge Paralakundi in his order dated 7/10/2024, while dealing with the bail application of the petitioner, has mentioned that he has sent a letter to the Deputy Registrar Judicial for the High Court of Orissa to place it before the court regarding the clarification to the order dated 25/9/2024, passed in ABPL number 6289 of 2024. The letter has not been placed before this court. The registry is directed to locate the same and place it before this court. Release the matter. Yes. Next.
My lordship, before
One.
my lordship.
Don't waste time. Registry has to place it on record here. Yes. I can't act upon your letter. Yes.
My lordship, kindly have it sorted, my lordship.
Yes.
I prefer
Next.
sorted, my lordship.
39.
Yes.
Please, your Lord. Perhaps my another senior for argue for some time, take some time, but that possible perhaps after one there is no
Today, partly heard Mr. Nando and Mr. Murthy for further hearing, please terms, sir, the entry mode to continue. Entry mode to continue. Yes. Partly heard coordinated, yes.
40.
Any date fixed or?
Kindly fix it.
Oh, okay.
40.
Mediation failed.
Hmm?
Mediation failed.
Mediation matter was sent for mediation. Over the mediation report. Where is the mediation report? Fact B. Let's see.
Press address is good, Lord. Return to sender, Lord. The noting is that.
Lordship,
Mediation report dated dated 18. mediation report dated 21/1/2025 indicates that the mediation has become unsuccessful. Least the matter, finally.
41.
Obliged.
May I please, your mercy. Here I have challenged the initiation of the DB Act case against the present petitioner, who is the sister-in-law and brother-in-law of the aggrieved person.
Issue notice to opposite party, let me move on. Yes. Next.
My lord, I have filed a IO also.
We'll see.
Because my lord, they are the central government servant staying outside. They are never shared.
Yes. Next.
Second also the brother-in-law and sister-in-law.
42 also.
42 also.
Same.
Here the 42, in 42, my lord, they are staying at the MP and the private.
Issue notice and you move application.
Apparent to mention item 37 IA is there. Not to execute the NBW. So 99.
Meantime, execution of NBW dated issued and so and so is dated. Yes. The rest of the, how many matters? Today is not possible. I don't think it can be possible today.
So, my lord, two matters are there.
There is a reference.
Interim order is there.
There is a reference. All interim order will be continued. There is a reference and everyone will go to the bar and all. And wherever the interim orders are there, it will continue and lease the matter.